Let me look at ownership for a second of the LLC, because this is one of the issues that I talked about earlier in terms of the founders' goals. And the founders, under the LLC form of ownership, are entitled to determine the eligibility for future ownership. That is, the founders can write into this document that is similar to a set of bylaws. It's called an operating agreement, and it contains all of the rules and formulas and procedures that will be enforced with respect to the LLC and the property. The founders can decide who can become an owner or a member of the LLC. And as I said earlier, almost all LLCs restrict ownership to descendants of the founders. That is, they want to keep ownership in the line of lineal descent. It keeps the cottage in the family. It also keeps the in-laws, by definition, it keeps the in-laws from becoming owners. So if we look at ownership transfers, then it's usually restricted to lineal descendants, and we can define permitted transfers any way we wish. And most families, and I encourage families to say that any lineal descendant of the founders is an eligible owner and does not require any particular approval process to become an owner. So parents can leave their ownership to their children without the need for a vote of approval. In terms of the children becoming new owners in the LLC. So we can define permitted transfers in other ways as well. And if the family has a particular identifiable group of people that they wish to allow to become owners, we can write that right in. And the most common way that that gets utilized is if the owners, the founders, have children with spouses that have been coming to the property for 30 or 40 or 50 years. It's not at all uncommon to allow the spouses of that generation, the first generation below the founders, to become owners. Because in my case, I've been going to my wife's family place for 43 years now, and I have the same degree of emotional attachment and commitment to that property as she and her siblings have. And so in some families, not ours unfortunately, but in some families we allow spouses to become owners with the condition that when the spouse passes ownership of that interest on, it has to go to a lineal descendant. So to use me for an example, I would, if I were to acquire an ownership interest, I would have to leave it to my kids. And I can't leave it to the second spouse that I have not yet married, but that's always a possibility. And I cannot leave it to people outside the family. I have to leave it to a lineal descendant. So we can do it that way with surviving spouses, and that's not at all unusual, quite honestly. And if I'm not working with the founders, but I'm working with the generation of heirs, and there are 3 or 4 siblings, and they're in their 70s, and their spouses have been coming to the property for, lo, these many years, in order to sell the whole thing to the family, oftentimes we include the ability of surviving spouses to become owners so that they don't feel as though they're somehow being cut out after all this time and energy that they have committed to the property. We can deal with adopted and stepchildren, and we frequently do. And most families will specify that adopted children, if somebody goes to the effort of a formal adoption proceeding, it would be appropriate to consider them as lineal descendants for all purposes of inheritance and eligibility of ownership as well. Stepchildren, on the other hand, are usually not treated that way, and in fact, most families say that they do not want stepchildren to become lineal descendants for purposes of inheritance. And a lot of reasons for that, but the point here is that we have the ability to determine whether or not adopted and stepchildren will be eligible to become owners. We can also have transfers that are approved by a vote of the members. And I don't do this real often, but on occasion the family will say, you know, we really want our neighbors across the street or whomever, somebody that has a very close connection to the family but does not necessarily have lineal descent, that is, they're not blood relatives. We can provide that if 100% of the owners approve a transfer to a non-family member, that transfer is then authorized and is legitimate. Again, we frequently say that at the end of the ownership by the non-family member, the ownership has to come back into the family so that it doesn't start spreading out among totally unrelated families. But it's possible for us to include an arrangement whereby if the members approve it, we can allow anyone to become an owner. Now, while we're talking about ownership transfers, one of the things that I want to stop and sort of do an offline discussion for a few minutes is on the so-called call option. And this is a forced buyout of difficult members. And one of the things that many families want to put into the operating agreement is an arrangement whereby if somebody doesn't follow the prescribed behavior within the operating agreement, they can be forced to sell their interest back to the company. The place where this is most commonly found is if somebody is obligated to make financial contribution and for whatever reason does not do so. And here, if somebody is delinquent for 3 or 4 or 5 years, it's not uncommon to have a provision in the agreement that says at that point in time, the company has the option to force that delinquent person to sell their interest back to the company. A lot of families feel that if somebody has not shown the commitment to the property to make the financial contribution for an extended period of time, it is better for the group as a whole to remove that person as an owner. Now, if the delinquency is for a legitimate purpose or reason, they're laid off, they have a medical issue that prevents them from working, for whatever the family feels is legitimate, then the call option is simply not exercised. So it doesn't require a sale, but it gives the company the ability to force a sale if the company, the other members of the family, feel that the delinquency is not for a legitimate reason. If you go this direction, though, it raises a couple more questions, and that is, if we're going to have a buyout, how do we value it? How do we determine what the purchase price is going to be? And then once we know what the purchase price is, how do we define how that purchase price is going to be paid? Because if the goal is to keep the property in the family the longest possible time frame, then many families feel that the payments should be extended over a period of years, because that's the way that you can make the burden on the people that are coming up with the purchase price more manageable and avoid a sale of the property altogether outside the family. The corollary to the call option is the put option before, and this is a feature that requires the company to purchase the member who wants out. Somebody has paid all their dues, they've been a good person, they've been a good relative, they've made their share of contribution of not only money but labor and effort, but for whatever legitimate reason they raise their hand and say, hey, I just can't do this anymore, or I do not wish to do this anymore, I want out. And again, it raises the valuation and the payment terms issues, but there is a very high likelihood of conflict if you do not have some provision in the arrangement that will allow somebody to exit the LLC and avoid the continuing financial commitment if they so choose. It may be they marry into another family, as I did. It may be they take a job in today's world in Shanghai, China, and geographically they just simply can't get back to use the property in a reasonable fashion, and they can't do it for the foreseeable future. And so in order to remove that financial obligation of making annual contributions toward the operating expenses, they simply say, hey, I want out. And we can put an option in the agreement that will eliminate the need for the siblings then to negotiate either the purchase price or the terms of sale. And it is that negotiation process that is going to have a very high likelihood of causing hard feelings. And again, I can talk from personal experience where my wife has an older brother that attempted to exit a couple of years ago, and the family went through about 3 years of very difficult and emotional negotiations on what that value should be. What is 25% of a family-owned property? What is that worth? And you've got somebody that wants to sell that is going to come up with a number that's high, and you've got people that are going to buy that have to come up with a purchase price that are going to want a number that's low. And there is no magic way of going outside and divining what that number should be unless the parents or the heirs have been wise enough to include a provision and a formula in the operating agreement that says if somebody wants out, here's how you figure the purchase price, here are the payment terms, here's the interest rate, and here's the number of years that the payments are going to be made. And by doing that, everybody knows going into the discussions of somebody that wants out that the price has been established, the payment terms have been established, and we don't need to negotiate what those are. And that will save the kids a huge amount of potential conflict, and I can just assure you, a lot of hard feeling.